It is an honor for me to form part of this panel. I will speak about the American continent, and I want you to put in your heads the map of the Americas. And I want to comment. Well, we have surrogacy, commercial surrogacy, regulated and practiced in some states in the United States, such as California, Arkansas, Ohio, Kentucky, states of Mexico, Tabasco, and Sinaloa. Then we have Colombia, and then we have Cuba. And also, there are altruistic surrogacy practices in Canada, in Brazil, and also in Uruguay, in my country. We have a law that has 10 years that enables surrogacy for women who are unable to gestate due to genetic or acquired diseases. It can be agreed with families up to the second degree of consanguinity, and it is forbidden that money is involved in the practice. But, well, having this map in our heads, in this panel we want to analyze what happens if a state wants to fight against surrogacy. Will it be helped or hindered by international courts? In my intervention, I will analyze what happens if an American state wants to fight against surrogacy, whether it will be helped or hindered by the Inter-American Court of Human Rights, that is the international body in charge of protecting human rights in the continent and also interpreting the American Convention on Human Rights. So I wanted to start with a very brief explanation of the Inter-American system of human rights. I know that most of you might not know that much of it in depth. So the Organization of American States is composed of 32 member states from all over the Americas. There are international documents signed by the OAS members countries committing themselves to respect and protecting human rights in the continent. And here we have the American Convention on Human Rights and other specific covenants. And there are two organs that monitor the protection of human rights in the territory of the member states. And these are the Inter-American Commission on Human Rights and the Inter-American Court of Human Rights. The Commission is the one that receives complaints and issues resolutions regarding human rights problems. And the court has a consultative and jurisdictional function. It issues rulings that are binding on states and is responsible for interpreting the American Convention on Human Rights. So, having said this, I want to analyze two questions during my presentation. The first one, what do the international human rights instruments signed in the OAS content say about surrogacy? And the answer is that there is no explicit reference to the issue of surrogacy in any of the human rights documents signed within the OAS, neither the convention nor in any of the specific covenants of human rights that were signed in the OAS context. But yes, there are articles that protect the children and also women, and that can give us some light to this issue. To put some examples, Article 19 of the American Convention of Human Rights that says that, and I quote, every minor child has the right to the measures of protection required by his condition as a minor on the part of his family, society, and the state, end of quote. We see the right of every child to be cared by his or her parents. And we also have the additional protocol to the American Convention in its Article 16 that speaks that every child has the right to grow under the protection and responsibility of his parents. And also says that a child of young age ought not to be separated from his mother. I think these articles give us a lot of light in this debate. And the second question, what does the Inter-American Court say about surrogacy? Has the American Court of Human Rights already ruled on surrogacy? And the answer is no. there is no judgment of the Inter-American Court of Human Rights that has dealt with a surrogacy case or addressed the issue of surrogacy directly. Unlike the European Court of Human Rights, which has ruled on several occasions and recognized that while there is no European law condemning, regulating, or permitting the practice of surrogacy, states have a wide margin of appreciation. And I guess this will be analyzed by Aude in some minutes. So while there is no Inter-American Court judgment that addresses the issue directly, there are two judgments that address the issue indirectly. And I want to mention these two judgments. The first one is the compliance monitoring in the 2019 case of Artavia Murillo versus Costa Rica, which simply mentions the term surrogacy. This is not a surrogacy case. It's a case about in vitro fertilization, but the court mentions the term surrogacy, and I'm going to speak about this in some minutes. And the second case is the case of Forneron and daughter versus Argentina. It is a case of 2012, which recommends criminalizing the sale of children with a specific offense and speaks of the obligation of states to adopt all measures to prevent any sale of children, including criminal protection. So I'll start with the first case, that is the case of Artavia Murillo versus Costa Rica, a case in which the Inter-American Court condemned the state of Costa Rica for prohibiting the practice of in vitro fertilization. A brief mention of the facts. In the year 2000, a ruling by the Constitutional Chamber of Costa Rica declared unconstitutional a decree regulating the technique of in vitro fertilization. As a result, 9 couples had to interrupt their in vitro fertilization treatments or travel to another country to have a IVF. They brought their case before the Inter-American courts, the Inter-American Human Rights System, and the Inter-American Court condemned the state of Costa Rica for this in 2012. The court found that by prohibiting the practice of in vitro fertilization, Costa Rica violated the American Convention on Human Rights, as it arbitrarily and discriminatorily interfered with the victim's private and family life through absolute protection of the embryo. While the 2012 judgment talks about the issue of in vitro fertilization, the compliance monitoring in this case, which is from 2019 that I was telling you, mentions the term surrogacy. So it is important here not to make a mix. It is not the judgment in the case of 2012, but the compliance monitoring of that case that was issued a few years later in 2019 that mentions the issue of surrogacy. So specifically, the court, in this case of 2019, handed down a decision in the case and declared that the state, and I quote, "The state of Costa Rica had complied with all the commitments assumed in the judgment, concluding that case." It says that the court values positively the steps taken by the state to hold a virtual forum on surrogacy, as it demonstrates that it is taking action to initiate a discussion on this issue, which is in accordance with the reparation approved by this court in the judgment. In view of the good faith of Costa Rica, says the court, in the fulfillment of its obligation and the commitment assumed by it to initiate this discussion, in a broad and participatory manner, the court considered it beneficial that the state continues to strengthen the discussion on surrogacy as a procreation procedure. I believe that it is hard to understand why the Inter-American Court mentions surrogacy when this was not the subject of the case in question. We see how the Inter-American Court overreaches in condemning the state of Costa Rica, imposing obligations such as the issue of surrogacy, which were not in the initial judgment, which was about in vitro fertilization. So now I'm going to comment on the second case, the one of a case of Forneron and daughter versus Argentina. This case is of 2012. It is a case in which a girl was given by her biological mother in pre-adoptive foster care to a married couple without the consent of her biological father. The court condemned the Argentine state for violating the rights of the father and his daughter to due process, judicial guarantees, and the protection of the family and identity. In this judgment, the court recommends criminalizing the sale of children with a specific offense. Specifically, it speaks of the obligation of the Argentinian state to adopt all measures to prevent any sale, including its criminal prohibition. There are very interesting quotes in this ruling. I'm not going to read them all, but afterwards you're going to have my intervention written if you wanna take a look at them. But I want to mention paragraph 140, and I quote: "The court considers that criminalization is an appropriate way to protect certain rights. The surrender of a child in exchange for remuneration or any other compensation clearly affects fundamental rights such as the child's liberty, personal integrity, and dignity, and results in one of the most serious injuries to a child whose condition of vulnerability is being taken advantage of by adults." I think that this can be perfectly applied to the case of surrogacy. And then paragraph 177, it is in the ruling of the court. It says, "The state must adopt the necessary measures to criminalize the sale of children, so that the act of surrendering a child in exchange of remuneration or any other compensation for any purpose or in any form is a criminal offense in accordance with international standards and the provision of this judgment." End of quote. So why do I think this case is important? Well, according to the 2000 optional protocol to the Convention of the Rights of the Child trafficking is the act or transaction whereby a child is transferred by any person or group of persons to another for remuneration or any other consideration. And this definition of child trafficking, I believe it fits perfectly with the definition of surrogacy that appears in a UN report of 2018, which states that surrogacy is the reproductive practice through a third party in which the intended parent and the surrogate mother agree that the surrogate will become pregnant, gestate, and give birth to a child. So, if surrogacy is a form of trafficking and sale of children in international law and falls under the crime of trafficking, then, following the criteria used by the Inter-American Court in the case of Forneron versus Argentina, states should adopt the necessary measures to criminalize surrogacy, as it implies a sale of children, so that the act of giving a child in exchange for remuneration or any other compensation, whatever its form or purpose, constitute a criminal offense in accordance with international standard. This obligation binds all state powers and organs as a whole. So, well, in conclusion, and to finish with my exposition, there are no human rights documents at the OAS level that mention surrogacy, but there are conventions that speak of the rights of the child and women's rights. Nor is there a judgment of the Inter-American Court that specifically addresses the issue of surrogacy. The only judgment in which the court mentions the term surrogacy is in a monitoring of compliance of a judgment on a case of in vitro fertilization. There are those who invoke this judgment to justify surrogacy, but the court has said nothing about surrogacy in that specific case. If we understand surrogacy as a form of sale of children, there is a court ruling that obliges the state to criminalize the sale of children. So this ruling of the court will be sufficient to condemn surrogacy. To finish, as a Latin American woman, I think it is important to analyze in depth the implications that the practice of surrogacy has on the rights of children and women. States are obliged by international human rights law to protect children and to protect women and to avoid any kind of violation of their rights. Latin America is a continent with a lot of inequality and poverty, and states must take measures to prevent surrogacy from taking place and further increasing inequality and vulnerability of people. Thank you very much.